Okay, I think we're going to go ahead and get started. Today is the last Human Rights in Practice series of the semester, and I am genuinely thrilled to be able to introduce and be in conversation with Professor Meg Satterthwaite. Professor Satterthwaite was recently appointed as the UN Special Rapporteur on the Independence of Judges and Lawyers, which was appointed to that mandate of the UN in October of last year. Professor Satterthwaite has decades of experience as an international human rights scholar and practitioner. She's presently a professor of clinical law at NYU School of Law, where she directs the Global Justice Clinic and is a faculty director of the Robert and Helen Bernstein Institute for Human Rights and the Center for Human Rights and Global Justice. Meg and I were just reflecting as well that 20 years ago this year, I was in Meg's first international human rights clinic at NYU Law School. So we are in an anniversary moment to this conversation, and I really am delighted to be able to have a conversation. We are doing today's event in a style of back and forth between the two of us, and then we'll open up the floor for any questions from you as well. And when we engage in the Q&A, I ask you to introduce yourself and your year as well. And we look forward to our conversation. Again, thank you, Professor Satterthwaite. It's been 10 years to get you here to Duke, and I'm delighted that we could finally do so. I'm looking forward to our conversation.
Well, thank you so much, Professor Huckerby. It is wonderful to be here, although being confronted with the fact that I started teaching the clinic 20 years ago was a little frightening. But it's really wonderful to be here with you, and it's an honor to be talking with all of you today. I do hope that this will be an informal discussion and it will have time for a Q&A as well.
Okay, so I'm going to start off just to bring everyone in the room into the mandate. So the mandate was established in 1994, very much in response to the need to document, to monitor, to improve the independence of judges, lawyers, and prosecutors, right, as well. Just talk us through a little bit sort of what the trajectory of the mandate has looked like over that time period and what your current vision for the mandate looks like.
Absolutely. So as you said, it is one of the older mandates, having been established in the mid-90s, and it was very much focused on civil and political rights violations against judges and lawyers, which has remained a very significant constant through the mandate and all of the mandate holders. The mandate really focuses on what are the basic needs, what are the building blocks to create judicial independence, what are the things needed institutionally for the independence of the profession of a lawyer, what do prosecutors need to ensure that they have the independence they need to make the system work. So those have been constants. There have been a variety of different themes that mandate holders have looked at over the years. One of them being corruption. So corruption is a really important and problematic and sadly enduring challenge for both the independence of the judiciary and also the exercise of the profession of the lawyer. There have been also a focus on, as I said, attacks on judges and lawyers, just their physical security, as well as the institutions that provide their independence. In terms of how I see the mandate, there are a couple of specific innovations that I'm want to bring, but also very much building on what has already been done, which is crucial. So if you think about judicial independence, you pretty much very quickly come to what is judicial independence about? Why is that a human rights issue? And if you are thinking about it as a human rights issue, it's pretty clear that it's about ensuring the rule of law. And it's about ensuring that there is a system that is set up to ensure that no one's above the law, no one's below the law, no one's outside the law, but that everyone can access that independent legal system that is then guaranteed by independent judges. So thinking a bit more broadly about what's necessary to ensure the independence of the judiciary at a structural level, at a normative level, and then also just at an everyday practical level is important. The second piece, when looking at the kind of two poles of lawyer and judge, is asking the question, what is the practice of the legal profession about? And of course, this is a question many of you probably ask every day because you're becoming lawyers or teaching others how to become lawyers. And the answer to that, again, is it's about helping people access justice. Mm-hmm. So it's about ensuring that people have access to legal advocacy, that they can really ensure their rights are fulfilled, and if they're not, that they can get a remedy for human rights violations and just rights violations in general. So that also then asks the question, who has access to justice? Who has access to lawyers, to legal support? And for me, that brings in questions around legal empowerment, which I think we'll be talking about, but specifically thinking about who has the right and the capacity to act within our legal system. And so I'm really interested in thinking about how to expand the answer to that question. So those are some of the things I'm thinking about.
Great, and I think we are going to come back to this particularly this innovation that you're really bringing into this mandate, which is being more inclusive and thinking about, when we talk about who does law and lawyering, who is comprising that group. So when you went through all of that, and I was just jotting down access to justice, it's rule of law, it's corruption. And one thing that I was struck by when looking at your mandate is what the breadth of international standards might be that inform your work. This is for everyone's background, special rapporteurs, independent experts in the UN system, sort of depending on your thematic or country area of nomination, you work with a core set of international standards, right, that guide how you can engage with states, how you can engage with other intergovernmental actors and so forth too. So what are your international standards, or what isn't your international standard when you work in this mandate?
Right, I think it's a great question. Because I'm looking at the mandate in this kind of more, in this broader way, it's important to both look at specific standards that relate to the independence of judges and the profession of the lawyer, but then also at the standards that undergird those and that undergird the capacity of people to access their rights and to advance justice. So if you look at the UDHR, the Universal Declaration of Human Rights, you'll see that the independence of judges is included there, and that specifically the right to a fair trial is included there. And then, of course, that is enshrined in the International Covenant on Civil and Political Rights. And some very, very important norms are set out there, specifically the right to a trial before an independent tribunal. That's crucial. And so that's one of the real cornerstones of this mandate. But then also the right to access a lawyer. So if you're brought before a legal system, not coercively, you're facing criminal charges, for example, you have the right to access a lawyer. And then if you're seeking to advance what the covenant calls a suit at law, you also have the right to an independent tribunal. So those are a couple of the cornerstones. But then happily and usefully, there are a set of norms. So what we might call soft law norms that have been established and are very useful and fruitful. First, there's the UN Basic Principles on the Independence of the Judiciary, which are really helpful in just setting out what those key norms are, what the specific requirements are that make up independent judicial functioning. There's also the basic principles on the role of lawyers, which again, set out what it means to have an independent legal profession. And then there's something called the Bangalore Principles on Judicial Conduct. And these were actually created by judges themselves to say, well, here is what judicial integrity looks like. Here is what it looks like to be an independent judge and the things that we need to ensure that we are acting with judiciousness, with judicial temperament, and with independence. So those are some of the kind of building blocks. But then, as you said, it's really relevant to look at other pieces of the whole human rights kind of framework, because that right to a remedy, the right to pursue and to vindicate rights comes up all over the place, of course, in relation to substantive norms. So those are all important. And then I would also just underline the right to equality and non-discrimination. And so that is another place where intersectionally, which I think we might also talk about, there's also a need to ensure that justice systems are fair and equal, and that judges act with fairness and equality, and so do lawyers.
I was saying, on that particular point, I'll go into the question more broadly. Your mandate recently made a statement in conjunction with other special procedures on the introduction of anti-LGBTI legislation in Uganda. For example, it's informed by that non-discrimination and equality approach. And one thing that's been really striking, Professor Southwick, watching your mandate, you came into it in October 2022. There has been a plethora of issues on which your mandate has had the occasion to intervene. So everything from macro level problems with independence, so collapse of the judiciary independence in Afghanistan, right, for example. Questions about judicial independence in Uganda, in Israel, big things you've been commenting on as well. And also your mandate has made a number of really instructive and instrumental engagements on questions of the targeting and killing of lawyers, right, of human rights defenders. And so to come back to one of the original inspirations for the mandate was that human rights defenders and lawyers can be targeted for their work, right, precisely because they are seeking to change inequality and non-discrimination in their countries. So let's maybe talk us through that, right? Because what are your criteria for determining whether the issue is one on which the mandate can engage?
Yes.
And also maybe also the format of engagement, like
right.
thinking through like what would be the most effective engagement from the
yeah.
mandate.
No, those are great questions. So, I mean, the first thing to say, I think, is that, as you probably know if you know anything about the UN system, all of the mandates are under-resourced. And I don't think that's a secret to anyone. Yeah. But I was actually told as I came into the mandate, oh, your mandate is the poorest mandate.
All right.
Literally, that was said. Okay. So we'll see what
starting
that
point.
Yeah. What does that mean? Yeah. It means that I have one staff member instead of 2 or 3. Yeah. It means that there were no grant funds existing. And that pretty quickly became very real when I started to think about criteria. So since you already mentioned communications, I'll start there. So communications are complaints that individuals or groups will write to me saying that they have a concern that comes under the mandate. So for example, a lawyer or a judge who's under attack, or a lawyer or judge who are experiencing incursions into their independence. And what I can do in that case is to write a letter directly to the government or other actor involved and seek their response. So I express that this appears to perhaps be a human rights violation. It appears to perhaps bring up human rights issues. And then I communicate directly with the government or other actor. They then have time, it's a confidential process, they have time to respond to me, to bring forward corrections if they feel that I haven't gotten it right, or to simply comment on my concerns. And then that becomes public after a number of months. I also have the capacity to make that public sooner if I think it's an urgent issue. So if it's particularly urgent, I can tell the government that I'll be acting to make this public within a number of days. They then, of course, also have the right to respond. So those are a couple of things I can do. It became immediately apparent that there was no way for me to act on every case, even that fit within the mandate. Oh, yeah. Sadly, and that's as a former advocate or advocate, depending on how you see that, I found that extremely distressing, and I knew it. I knew it theoretically, but then experiencing it is a whole different thing. So it does require that I come up with criteria. So certainly one of the criteria is urgency. There's no question. Another is things that are representing a larger pattern. So in some places you'll see, one human rights defender, a lawyer who's getting attacked for their human rights lawyering, but that there are perhaps dozens more in similar circumstances. So that's something that's helpful to look at. I think it's also helpful to look at whether there appears to be space for that engagement. And that it may be that there's an opening with the government, or it may simply be that there are advocates who are ready to act and feel that your intervention will be helpful. Of course, I also do basic checking. So the standard for this is really essentially a prima facie case, because I'm just making allegations. I cannot determine whether a violation has happened or not. But I still think it's important to check to make sure that they're well-founded, that they're not abusive, because we don't want to be bringing forward allegations that are not well-founded. So that's another piece. And then I would say that another piece of this is simply, are these cases that are also not only necessarily in that specific country, but are they sort of showing and illustrating a trend more broadly that will be important to comment on? Those I would say are the basic criteria, but my hope is to also expand the capacity of the mandate to respond more broadly about kind of urgent actions. For country work, again, I knew that I have to have an invitation to go to a country, and I knew that might be a challenge. But I think I'm seeing it again as it's a give and take with governments around kind of what do they get out of it? What can I bring that's useful to them? And I do think there's a lot of that, but I haven't had the space to kind of show that yet. So I'm trying to talk to governments about that around capacity building, around exchange of knowledge and sharing insights, et cetera. And then talking about why it's useful to allow me to engage with justice actors, even if there are challenges in a country. And so those are country visits, which I think I'll have more to say once I've gone on one. But we'll see. And then thematic reporting. So I already had to turn in my first thematic report, which is basically kind of here's how I see the mandate. And I get to write 2 of those a year. So they feel kind of precious and, because there's not that much you can address in them. Also, just FYI, they're always 10,700 words. So it's a very strong limit. So what I'm trying to do there is to look back over what has already been covered by this mandate. And I'm looking for gaps that I think might be important to fill. But also, as I already said, I come in with a certain kind of vision of the mandate. And so I'll be advancing that as well. So it's a bit trying to adopt a little bit of an opportunistic approach, of maybe a negative way of saying it, but something that says, okay, well, what are the things that are happening in the world that haven't been covered yet that might be useful? And then also, how can I advance these specific priorities that I have, because I think those are important.
And when you were talking, I was really thinking through, a recurring theme that comes up in our class seminars and in clinic spaces too, which is, what is the efficacy of engaging with a state actor, in these moments, right? Because particularly in the context in which you're working, very often it's the governmental authorities who are comprising the threats to the independence of the judges and the lawyers. And so maybe you could say a few things about, because you mentioned it in your remarks just now, what are the motivations of government to engage with your mandate?
Right.
If you are taking a critical posture toward them, what gives them any incentive to respond to your overtures?
Great question. So I think there are lots of reasons that vary from the most kind of earnest and just interest in capacity building and ensuring that there can be space for judges, for example, to have experiences with each other across borders. And I can kind of facilitate some of that. There's also, I think, an openness to innovation in this space as well. And so those are some of the reasons. There are frequently governments that feel like they want to support their judiciaries but don't have, the money or the capacity or whatever it might be. And they might see this as a helpful way of kind of showing the international community that they're open to this work. There are also governments that perhaps might see it as a useful signal. So perhaps, I could let this rapporteur come and that will show that I'm committed to the rule of law. And, that could be more about externally facing things, signaling, you might say. And then I do think that, there can be times when it doesn't look great if you're a state and you're turning down every invitation. So then those are, again, sort of strategic moments. Another moment that I would mention that I've seen other rapporteurs kind of move within that have been very fruitful are times when governments change. So a new government might come in and they may feel like, well, I'd really like to improve the independence of the judiciary, or I really want to make sure that lawyers have the space that they need to work. And we really could use some help on this because we know that our predecessors didn't do so well or maybe worse. So those can be some times that are useful. And I'll check back with you in a couple of years to revise what I just said, no doubt.
So this is one of the big questions, which is really, in the current moment, where, if you were identifying, you mentioned the urgency and the patterns, as like some of your criteria for thinking through navigating the volume of issues. What would your mandate see as the greatest threats to the independence of judges and lawyers right now?
Okay. So I think one that's really important to say immediately is autocratization and democratic backsliding. So these are both, so autocratization would be moving further toward autocracy by a government, no matter where it sort of starts in the spectrum, if you see a spectrum from democracy to autocracy. So it would be moving further down that line. Democratic decline being that you start with a fairly democratic state and you start to see those norms pulling away. Important because, unfortunately, around the world, there's a bit of a playbook on how to make both of those moves. And they have in common often attacks on the independence of the judiciary in particular. And so it makes sense, right? Because the judiciary often plays a role of checking executive power, ensuring that the branches have oversight and are acting constitutionally. And so sort of reducing the power of the judiciary in one way or the other is often a step that's taken by autocrats or that's taken by governments that are becoming less democratic. So that's a crucial one. Another is just how are courts and lawyers facing huge international crises, including specifically climate change. So courts have come under a lot of pressure here, both through strategic litigation that might ask them to do very bold things or things that perhaps actually then bring into question what is the role of the judiciary. And so I think that that's really important to look at. And also the issue of the climate crisis brings in a lot of expertise that's required. So I think that's important as well. Digital technologies, so I think everyone kind of has those on their mind right now, the debate over AI. But for this mandate, it is AI and it is around automated decision making, I think. It's important to look at that in this space. But it's also just digitization, right? Because there still are legal systems where, for example, the court of first instance, none of the cases are available for anyone. They aren't digitized. So it's that whole spectrum of things, but the AI being, I think, really crucial. The next one I want to talk about is complicated because the words are not that well established yet. So undue influence of economic actors on judicial systems. And some people would call this corporate capture, but I'm not only looking at corporate capture, I'm actually interested in kind of economic capture, but I also am going to put that in quotes because I think it's a very tricky and slippery idea. What I'm getting at here is, are there economic actors that have privileged access to judicial systems and are able to use that in a way to unduly influence? And that's something I think that some of the human rights bodies are looking at a bit. I also think it's really important to look at the independence of indigenous peoples' judicial systems. And so I hope to do a thematic report on that. Systematic inequalities and the way that they influence judicial systems, both for judges themselves, but also for litigants, and then also relating to the legal profession. There are lots of challenges to judicial integrity, including some that I've already mentioned, including corruption. There are issues around just the status of work for judges that need to be still looked at. In terms of the independence of lawyers and access to justice, the targeting, I already said the targeting of the judges, but I put it in autocratization. For lawyers, it's not only those autocratizing spaces, but it's many spaces where lawyers are directly attacked, exactly for the reason you said, which is they're often identified with their clients. And that is, it's a basic principle that lawyers should not be identified with their clients, but it's one of the things that happens often and puts them in vulnerable spaces. Also dismantling harmful structures and practices within the profession. So that does have to do with equality and non-discrimination, but it also has to do with, I think, some of the vestiges of other systems. So if you think of post-colonial settings, for example, there are still spaces where the lingua franca of the judicial system is the colonial language. And so that means that people can't even, I've seen this myself personally in Haiti, where people would come in, the judge would be speaking French, the lawyer is speaking French, and the client might only speak Creole. And so they don't even know what's going on. So I think looking at that a little bit more would be important. And then finally, this piece that I've already spoken about, which is closing the justice gap by expanding the legal ecosystem and expanding access to justice.
And I want to come to that and spend some time in the legal empowerment model that you've envisioned for the mandate and also in your scholarship and other work as well. Before we go to that, to come back to that, the through line of much of what you discussed in terms of the undue impact of economic actors, the access to post-colonial but heavily colonially imprinted systems, really does turn on equality, non-discriminatory norms. And so how much, or in what way are you integrating the intersectional lens into this mandate?
I think it's absolutely crucial to use an intersectional lens. And it is everything from kind of the structure of the systems themselves, kind of bringing that intersectional questioning lens to those structures, and also to who are the different actors in the system? Who are judges? Who are lawyers? Who are litigants and people who are coming before the courts? And I think that there are we know there are very robust norms around substantive equality and non-discrimination under the human rights corpus that give us a lot of tools to start to address these issues.
Yeah.
And I think a lot of it for me is simply putting those on the table that have been quite apparent for so long, and we know this here in the US. It's very apparent that structural racism impacts the legal profession. That is not a bold statement, it's simply, a description. So I think we need to be saying those things a bit more clearly in this setting as well, and talking about what good practices are for taking on board the dismantling of structures of inequality. I also think that even just talking about who judges are, so I've started to have this conversation and looking at the data also. There's significant data on gender for judges, but only in a binary sense, how many women, how many men. That exists in many, many countries. But when you start to ask other demographic questions about just, dominant groups and subordinated groups, or groups that are identified by different forms of racialization, or LGBT judges, you suddenly have very little data in most places. And so I think even just asking that question is important in this setting. So those are a couple of the things I'm thinking about.
And it sounds like, just also looking at the existing work your mandate has done, is you're also very much breaking down the silos that exist, like in the special procedures, right? Because we have a special procedure on anti-racism, we have a special procedure on women, right? And you're sort of saying, no, that doesn't actually make a lot of sense to work in those siloed ways.
Without trenching on their
mandates. Without going on their mandates. But doing the collaborative work, for example. So the collaborative statements. Right. Yes, it was not a territorial grab, but more of an ability to work together to see those different synergies.
Exactly. And I think really they bring so much expertise. So that piece of kind of working very closely with other mandate holders has been already to me in the last couple of months just so fruitful. Because you can see the insights that people are bringing from their different mandates, and it just makes sense for us to work together more. I think. Even though it is inherently, of course, more work.
And maybe I want to make a question about that, and then maybe break up our pattern and actually ask a Q&A on the mandate, and then we can go into the legal empowerment. Is that okay for you? To get everyone into the conversation as well. So I was wondering, maybe it's not familiar to many in the room who are new to the UN human rights mechanisms, but definitely a shift in the work of special procedures has been to do more collaborative work, right? To do joint statements, to do sometimes joint communications, of course. And part of that is a response to the resource constraints that you outlined. Part of it's a recognition that the issues on which mandates are working are cross-cutting and inform any given rights and abuses. Can you talk a little bit about that process of collaboration and what that means for mandate? And then we'll go to the any questions on thinking about mandate-oriented questions. We'll come to the floor, and then we'll come back to the legal empowerment piece too.
Yes, I would say that it has been wonderful to kind of approach other mandates with ideas around how we could collaborate. So just as an example, there's something called the Day of the Endangered Lawyer, which happens in January. And this year it was on Afghanistan. So I knew that kind of, a couple of months in advance. So I approached the Special Rapporteur on Afghanistan and asked if he would be interested in doing something together. And I just found that process incredibly helpful. He has such a depth of knowledge about the legal system in Afghanistan, and we were able to do a bit of work together. And something I never could have done on my own. It would have just been too difficult, too much work, too much time, et cetera. So that was great. There are, of course, drawbacks. The main drawback, I would say, is just it takes more time. So, if you're in certain circumstances, I've just gone ahead and done something on my own because it felt really urgent and I wanted to get it out quickly. But I do think that all of us kind of within the system are very open to that kind of collaboration and see the value in it.
So let's take a break from our dialogue. And I've got lots of questions on legal empowerment that I definitely will get to. But I want to open up the floor to anyone who's got any questions about what we've been talking about so far. And again, please introduce yourself prior to asking your question and join the conversation. There's very much a chance to learn more about the ways in which this mandate is being envisioned and implemented.
I'll defer to any students.
Nobody's hand is up yet.
Why don't you start first,
Okay.
Professor Helfer, and then we'll, and then Noah, is your hand? Okay, brilliant. Okay,
So-
so Adme as well.
Great to see you, Meg. It's been too long. And I appreciate everything you said, and I agree with it. I just have one question and one suggestion. The suggestion is when you're thinking about the private economic actors, the extent to which might look at compulsory arbitration clauses. It's obviously something that's
Yes.
very, very
Yes.
big in the United States, especially for whether they cover civil rights claims.
Yeah.
But there was a trend in Latin America in the same way in the 90s. I don't know where that is now. But privatized justice,
Yes.
which is not so much what you were suggesting earlier, that certain corporate actors or economic actors have privileged access, but in fact they take it out of the legal system. So that might be something to fold in there. So that's the suggestion. to think
Thank you.
about. The question is one I very much ask myself all the time in the work that I'm doing in Geneva, and that is, you described all of the ways, and very eloquently, that you try to incentivize state participation or being somewhat open because it's in their interest, as well as using normative, value-oriented arguments. But the challenge that I've sometimes faced is, yes, you can focus on those issues, but then you may end up leaving behind countries that are much more close, that really are not interested
Right.
in engaging. And given how broad the scope of what you're envisioning is, and appropriately so, I just wonder how you think about whether you put some of those countries to the side and say, look, we're just not going to make any progress right now, let's wait for a regime change, or whether there's some strategy you've come up with or are thinking about, if you haven't implemented it, for how you might try to engage those states that are really close.
An easy question from Professor Helfer. Well, thank you. On the first one, thank you so much. I think that's a really great idea, and I'd love to talk to you more about it. So I do think that I don't have the right / it's not my role to put any state to one side in that I need to be non-selective. On the other hand, of course, you're pointing out the right issue, which is strategies for engaging. The easy answer to this, or one easy answer is, and again, somewhat surprising to me, is that some lawyers and judges from some of those places are asking me to, for example, do a communication. So that's really helpful because it gives me a relationship directly with rights holders who think that there's some value in engaging in the system. That's been a bit of a relief to me, honestly, because I didn't know whether to expect that or not. With country visits and the like, I think that will be very difficult, but hopefully not impossible. I do think that the first couple of visits will be important so that countries can see what might be fruitful coming out of that system. In terms of thematic reporting, I do think, again, that's a place where I have a bit of capacity to engage in some of those spaces by getting submissions or by looking at scholarship, looking at different forms of work and investigation that have already been done in those places. So not a great answer for you, but I agree, we just need to be creative, right?
And just for everyone, before we go to Noah, just to contextualize, so when you do a country visit as an independent expert, you can't just turn up and do what you want to do, like in country, right? There's a highly negotiated process of getting an invitation, but then around terms of the visit too, in terms of like location, if you can visit detention centers, if you can visit certain spaces in the country. So just to note, there's a lot of, for every mandate holder, there's a lot of behind the scenes work that's done on establishing both the consent to a visit, but also that the visit would take place on parameters that are acceptable to the mandate. And most mandate holders are quite strategic in thinking through what types of countries, what geographic spread would be meaningful for the mandate too. So there's lots of behind the scenes stuff happening in that regard with, in the work of the mandate.
Thanks, Professor, and thanks so much for being here. My name is Noah. I'm a 1L. I think my question is sort of along the same lines as what we've just been talking about. I'm wondering if you can speak to the kind of institutional constraints you feel like you have, especially coming from the side where you can kind of say whatever you want. You can make, the criticisms that you feel deep down are true. I mean, in what ways do you feel that you have to hold back now in order to preserve the mandate?
Yeah, that's a great question. So, I mean, I already mentioned kind of the literal funding issue, which is actually, I think, quite large for mandate holders. So that's an issue. I think definitely that kind of making the case for why states might want to engage with the mandate is really important early on. So I wouldn't say that it's holding me back, but I feel conscious of the need to try to do that. And that maybe is different than some of the advocacy I've done in the past. Certainly, if you're litigating against the state, it's a very different strategy. On the other hand, it's similar to some advocacy where you're working closely with, a ministry, for example, or, working on getting data about an issue that the government really wants data on also. So I do think that there's some similarity to work I've done in the past, but it is, there's a need for strategy there. In addition, there's a code of conduct that I have to follow. And so just as a basic, the most basic requirement is, for example, that I always need to bring my concerns to the state first. So just as an example, Twitter. So Twitter, I can't just tweet about something because I need to go to the state first. So I need to go and engage formally with the state before I can tweet about a case. So that's been, it's a totally different way of tweeting, right? Like it's suddenly very formal. And, I used to have a certain tone on Twitter. And so I had to get rid of my Twitter account and start anew. But that's, I think, really helpful also because it's a basic kind of due process guarantee for the state that they get to discuss with you and engage with you about those issues first. I think that's completely legitimate and makes a lot of sense. But it is different than maybe I would have done in the past, although it's also similar, right? So if you have a clinic report you're writing, you're going to give the government an opportunity to reply, or you're going to ask the company to give you their views. That's just kind of a basic fairness. So I would say it's more formal, it's more structured. There aren't as many resources, maybe. And then I think there are these genres also, because the communications are a specific genre, it's a certain kind of letter that you write. A UN report has a certain form to it. And so those things I'm getting used to, and also trying to build additional things so that I'm not totally constrained by them.
I was reflecting as you were talking that the state-centric approach to advocacy still very much informs us in our human rights spaces, and where you do in practice have some engagement with the state around what you're going to be reporting on or engaging with them on, and as a means of being effective too. So
exactly.
It's a more formalized Professor Admey. And then we have Olivia and Diana.
So guys, thank you for coming. I've been looking forward to you coming for so long. You got your girls together. It's nice to see you here. I want to actually ask the opposite of the question Noah asked, where he's saying how you have to behave differently because now you have this formal role and you have to adjust to kind of vibe you bring to it. So as a Fletcher girl and somebody who is worried about the ways in which rule of law speak the mystification process around the law, so that in fact when you engage with these countries, you can easily be misappropriated, so that the signal they send is really a cynical signal that you enable because they have no intention of engaging with you. And what they have as an intention is to use you. And they think that you're stupid enough to be used. Right? So, and you might be. And I'm just thinking there's some voices in my head. One of them is Dan Moyne, who, every time I meet with him, he's just so disappointed with human rights and just so actually dismayed with the degree to which we're played. And I think that he makes it harder for us to actually do our work by how much he thinks we're stupid. But I also am sort of thinking about the work around legal alienation, where the mystification role you could play.
Yep.
I wonder if you could speak to rapporteurs who've gone before you, like your colleague Philip Alston or Zendaya Chidi, who's one of my favorites. You know, how will you adapt some of their
Yeah.
modalities for not being played?
Right. I love this question, and I feel like I have no really great answer to it. I think that you're absolutely right. I love the way you just set things out. That you know, you could easily be played so easily. How does one avoid that? I think first of all by knowing that and trying to understand the ways in which countries are perhaps hoping to utilize use your signaling, etc. As to kind of the Philip Alston, Tendai Achiyomi piece, like of course every rapporteur has to be their own, brings their own style. I feel that, and I've said this before, so this won't be a surprise to Philip. I think that Philip Alston's style, it's about who he is. First of all, he's brilliant. I just want to be really clear. He's absolutely brilliant and very effective. He's extremely effective. But I can't do that. I'm not Philip Alston. I think it has to do with him being a white man, to be honest, from the Western Europe and other group. And so I think that those are all important pieces. And I think that, you know, if you have that, you can utilize it in a certain way. I need a different style. Tendai Achiyomi, similarly, I think is brilliant. I absolutely admire what she did with her mandate, and I feel like I'm already kind of learning from it on the job in terms of being able to say things that have not been said, right? Like just things about the system itself having these structural problems. But I'm still trying to find that exact voice, I would say. You know, I think it's something as professors, we work to find our voice, you know, going through the tenure process. And it's, you know, it's like very specific. And then coming to this role, it's a similar kind of a process, but very different. And so I think it is about knowing the strategic possibilities and the limits, and then the misuse, right? It's the use and misuse all the time that's possible of whatever I might say or do. So all of those things are very much on my mind. I don't have a great answer for that yet, except to say I think you're right that it's a crucial thing to be thinking about. Thank you.
There may also be times when you know you're being used, but the payout from that is still worth it, right? And so thinking through those
Well said,
things
Jane,
too,
yes.
right? Because it's just the ways in which you may be used to give a veneer of legitimacy, but by virtue of doing a country visit, you've been able to access different communities and start a different conversation, right?
Yes.
So it's kind of constantly seeing those two pieces like as well. Olivia?
Yeah, thank you so much for being here today. My name is Olivia. I'm a second year. Back to the topic of collaboration with the UN. I guess I'm just wondering, like, have you ever faced or heard of issues between, like, in efforts to cooperate, like issues of like territoriality or like a certain like UN expert kind of wanting to take the lead or the reins because it's like their area of expertise? And if so, like, you know, how have you dealt with that, or how would you recommend dealing with that?
No. I think that's a great question, especially because there are so many mandate holders now. There are just like dozens upon dozens. There is a bit of kind of a non-spoken rule, which is if things that are kind of squarely within one mandate first, one should defer to that mandate holder. So I think that helps a lot because it helps us to know kind of to not stray from our lane without talking to those folks, without ensuring that we get their views. Of course, we're still independent, and so if we disagree, we can carry on our path. I haven't heard of any radical things where that has become a huge problem, but I've only been doing this since November. So I would say, generally speaking, there's a very collegial sense among mandate holders. We tend to defer to each other's expertise and also just seek it out because it can be so helpful.
I mean, as you were speaking, Meg, I was thinking through, very much that model relies on there being a common vision of what human rights protections are enshrined under international law and to whom they extend, and that's definitely something that's become, it's not for your, because you can't comment on it, but from an operational perspective, has become an issue, for example, with the rapporteur on violence against women, its causes and consequences, who's recently begun to express publicly some quite anti-trans perspectives, like on Twitter and other spaces too. And so just to know, I think this model of collaboration is such an extraordinarily powerful one, and it's interesting to watch as an advocate, thinking about where are the fissures potentially,
Yes.
and like how do those, how does potentially one mandate holder taking a stance that may be antithetical to an understanding of human rights protections affect collaboration of possibilities, but also the legitimacy of the system, like, too. And so,
And I won't comment on that as you guessed,
Yeah.
but I will say it's helpful to be watching in that way, right?
Yeah.
Because it also
Mhm.
informs your advocacy and
Yeah.
your strategy for
Yeah.
engaging with the system.
Diana.
Hi, I'm Diana. I'm a 3L in the JLM program. I was wondering how your mandate, or if your mandate, approaches the processes that countries use to select judges. It seems like that's one way where the independence of a judge can be threatened before that person even becomes a judge. But then also on the country level, there's a lot of variance in what processes look like. So if you have sort of a set of best practices or indicators that you look for in
Great question. So the answer is yes. It's a highly relevant issue. It's one of the main issues where the judiciary gets very politicized, as you can imagine. So there are some basic principles in the norms that I talked about before that talk about how those processes should go. At a very basic level, the idea is that there should be more deference to expertise and less deference to politics. That's kind of the main thrust of those norms. But what that means in practice is going to be very complicated. And the independence of the judiciary, because it is in part about a structure, it will look different in every country, right? Because it will depend on the constitutional structure, it'll depend on the institutional relationships. But at the end of the day, the question is, are judges being chosen for their merit, for their integrity, for their capacity to do the job? Or are they being chosen because of what politics they bring, because of what party they belong to? And so that's kind of the rough way of talking about it. But the mandate has done a lot on different country situations where you can see those things changing. And when you see them changing, the question to ask is, and I can speak about Israel because I've engaged with the Israeli state on this, is to ask if this judicial overhaul that's being proposed in Israel right now, it fairly clearly would increase the role of the political bodies and decrease the role of judges specifically in choosing other judges. And so it really is a move toward politics. And then it also has some, what I would suggest are likely incursions into the independence of judiciary by taking away certain standards that the Supreme Court has developed, for example, the reasonableness standard. So depending on which of those proposals actually come forward, the way of analyzing them is to look at the structure of the Israeli government as a whole, and then to see how those things are moving and what what is changing. I hope that helps.
it does.
Okay.
Thank you.
Lots of questions coming up. I was right to break in the midst. Cameron.
Hi, I'm Cameron. I'm a 3L in the Dating LLM program, and I kind of had a question about how has COVID impacted people's access to
Yes. Such a good question. So my predecessor did do a report on COVID, and I would say, some of the things that he looked at were emergency orders, right? That either shut down courts or imposed certain restrictions and maybe often took away some of the capacity of the judiciary to review those things. And he asked, have these gone on too long? Like, are they fit for purpose? Do they fit under the ICCPR's standards around derogation if they actually involve derogations, this kind of stuff. And unfortunately, the answer to that is a lot of those things have endured and of course, unfortunately, may continue to endure that should have been withdrawn. That doesn't answer your direct question, which is people's access to justice. So one of the interesting dynamics, I think, is that there's mixed data depending on what you're talking about. So in some places, some forms of, for example, virtual appearances, virtual court, virtual hearings, some of those seem to have had an expanding access to justice impact, but in other spaces they have been negative. And of course, partly the reason for that is there's a digital divide that happens to fall along the forms of discrimination that we're all familiar with. So I think it's very contextual answer to that, but the evidence seems to suggest that there are enduring access to justice problems that have come up through both emergency measures and then also earnest measures to try to keep systems going, which are important. And so hopefully there will be like really robust lessons coming out of this, as well as continuing return to non-emergency measures going forward.
Before I go to our next question, I was struck earlier in our discussion, you mentioned the importance of emphasizing good practices that emerge in this space too. And something on which Cameron has been working is the project that we run out of our clinic here, which is a COVID tracker that's looking at exactly seeking to capture moments of progress in rights, right? In moments of crises, you can have deprivation and undermining of human rights, but you can also have an opportunity for growth and for challenging of governmental structures. And so it's the idea of like, what is a good practice and turning from purely critiquing to offering different models to states. It's an interesting shift, I think, in a lot of human rights advocacy as well. I'm sorry, I don't know your name, so please introduce yourself.
My name is Jacob. I'm a third year undergrad. I was just wondering, how do you open a dialogue with the country if maybe the country is closed and then there's a regime change, now they're open, but the population and the government might view the West with deep suspicion, and might view the UN as an extension of America specifically, or the West in general.
Yeah, I mean, I think that's totally right. I love that question. So, I mean, because of the mandate, I do have formal ways of engaging a state first. And so it is actually quite formal, the way that I would start speaking to a state, usually through the ambassador in Geneva specifically. If there hasn't been a history of that, it might take a bit of time to just sit down with the ambassador and start to have a conversation. I, of course, being a white American woman, have particular expectations placed on me, I would imagine, and also assumptions around kind of what I symbolize. And so I also have to, I think, be very aware of that and accept that that will be a likely dynamic. Hopefully I can show that I'm trustworthy, that I'm rigorous, that I'm doing the work independently, fairly, and non-selectively. So, I guess those are a couple of my answers. I would say that governments that are trying to make this shift, I think they tend to reach out, not always. One of the things I just said, of course, that won't be true for every country is not every country has an ambassador in Geneva, right? So that's another thing, is kind of figuring out ways to open lines of communication where that kind of traditional approach might not achieve what you're looking for. Yeah, it's a great question.
Thinking that trustworthy and rigorous could be like things that you have engraved.
Exactly.
And they very much reflect your entire approach to this work. Yes.
Hi, I'm Jen. I'm also a my question outside of the method of communicating with parties, not necessarily just state government agencies or other institutions, what kind of a tone do you use? I know that you talked a lot about having a collaborative process, but I found that it can be really frustrating.
Yes.
Try to maintain my own composure while some other party does not
That's really interesting. And I can imagine some situations you might be thinking of. So I would say that it is really important to maintain composure for me in this setting. And I think a sense of openness and listening. It is the case that I'm an advocate, but I also am meant to be and want to be like a real interlocutor, not only someone who's trying to drive a point. So I think that's crucial. Your point, of course, is partially the other side might not be doing that, right? I guess my feeling about that so far is that if you go in with that openness, of course, retaining the commitment to basic human rights norms, not ever compromising on that. But there will usually be some space for discussion. So it's a bit about finding where those spaces are. And the good practice discussion can be very helpful, because I think everyone wants to do things well.
Better.
We just disagree with what that might mean. So it can open doors to conversation.
Yeah.
But yeah, sometimes there's just nothing you can do about that, depending on who you're talking about. Yeah.
Jamaris.
Hi, my name is Jamaris. I'm a 3L and JDL employee as well. So we talked a little bit about the trends that you've encountered in barriers to access to justice. I'm just curious if you noticed regional trends, that countries in a given region is
So I definitely think there are regional trends. I'm not going to opine about them off the cuff, though. But I have been looking at them. So I would say yes. There are also commonalities, and I don't know if it's the comparing of the playbook or if it just happens, but certain kinds of, and I think this question of the appointment of judges is a good one. Like you can see certain of the things that have changed in one region are actually being taken by another. Or is that because they're watching each other? I don't know. I do think it's important to look at it regionally, in part because some of the questions are, how can you influence those trends? And regional systems are really crucial in some regions, right? In other regions, they're not as crucial. But certainly formal regional systems, human rights systems, economic systems, other kinds of things. So yes, I think it's important. I'm not going to say anything substantive about it, but I do think you're right to bring it up.
I'm just going to end, Megan, the few minutes that we have left talking about your work on legal empowerment. It's going to be the topic of your upcoming thematic report to the UN General Assembly. Whatever you want to say about legal empowerment in 3 minutes.
Okay, great.
The floor is yours. I'm not going to go into any detailed questions like legal empowerment
Awesome.
from your perspective.
Okay, so what is legal empowerment first?
Yeah, that'd be great.
So I think that to just to pull back for a second. Legal empowerment is one strategy to overcome what's been called the justice gap. So there was in 2019 a big study done by a task force that looked specifically at who has access to justice systems, justice remedies, and who doesn't. And it's really striking. I'm just going to give you some statistics because they're, I think, very striking. So the big headline figure that's often brought out is 4.5 billion people were estimated to be excluded from the opportunities the law provides. Perhaps they don't have legal identity papers. They might not work in the formal sector, so they're not protected by certain kind of wage and hour laws, for example. The second is 1.5 billion people who have justice problems they can't solve. So those might be crimes they've experienced that they can't get resolution for. They might be a civil or administrative justice problem that has no solution that they're aware of. And then a horrifying 253 million people live in extreme injustice, which includes 40 million people subjected to modern slavery, 12 million people who are stateless, and more than 200 million who live in communities where high levels of insecurity make it impossible for them to seek justice. So this is like a huge problem. And so the answer is not everybody gets a lawyer. I think at a very basic level. The answer has to be around making the justice system more accessible on a very real basis and on a significant basis, I think. So legal empowerment is one approach that says, lawyers should not be gatekeepers, but we should be door openers, and we should be accompaniers, essentially. So if you think about it, if you have, let's say, a landlord-tenant issue, if tenants know their rights and are able to advance their rights in conversations with the landlord, that may help them simply negotiate a solution to a problem, right? Just at a very basic level. It also may help them figure out who to join forces with in order to change something. Or it might help them understand that, the law is actually not on my side. I need to go to the city council and have it changed. So it's a way of ensuring that people can know the law, use the law, and shape the law. That's something that Vivek Maru often says, and I think is very helpful. I think also I'd like to add it can help us transform the law. So in places where law is actively harming people, it also needs to be transformed. So that's something. Very specifically in my last minute, it does include embracing additional legal actors. And I think this is important to talk about at law school. So not just lawyers. Think about the public health system. There are medical doctors with medical degrees, but there are also nurse practitioners. There are femsage, what do we call them? No, these are birth attendants, traditional birth attendants. And then, yes, physician's assistants and nurses, right? Like there are all of these people, and then community health workers. But in the legal system, it's like you have lawyers, right? Sometimes we have paralegals, but those tend to be people who work at law firms in the US. So what legal empowerment says is, what if there was an expanded legal ecosystem where there were graduated responsibilities? And of course, lawyers, just like with health, if you need surgery, you're going to a doctor. You're not going to go to a nurse. in a legal problem, with a legal problem, there might be something that's very basic that trained people who have knowledge but are not lawyers can help you solve. So that's the basic idea. And at a systems level, it requires a conversation where lawyers see those folks as allies, not as competitors. And what I've found is the lawyers who actually are engaging with this work do see it that way. And judges especially do. Judges who see that pro se folks come before them and really are like just at a loss, but could be helped by someone that doesn't have to become their lawyer. Judges really get that legal empowerment can be very effective. So there's also a lot of evidence showing that now, that it can make a dramatic difference in legal systems. So that's what legal empowerment is. And that's what I hope to talk about in my next thematic report.
I'll be looking for that. So thank you to the Special Rapporteur for coming. I continue to learn from you every day. So we're
And
good to be in
I
conversation. So thank you for coming and spending the time with us. And we continue to wish you all luck in your mandate.
Thank you very much. Thanks for coming.